Good day, everyone. Eric from Helps Nonprofit Law Firm. Welcome to have you here today on February 17th, 2025. Let me know if you can hear me okay. My name's Eric. I've been an attorney for 46 years, founder of Helps. Helps is a national law firm that represents seniors and disabled persons who owe debt they can't afford to pay. We protect seniors under a federal law called the Fair Debt Collection Practices Act that provides that if you're represented by an attorney, debt collectors can no longer call or send demand letters anymore. They have to leave you alone. And that's what Helps is here for. When people find out about us, they enroll, they send us the creditors they owe money to that they don't want to pay anymore. We send what's called a cease and desist letter, and the creditor they can't call you or send you demand letters anymore. And then we represent you ongoing, so you don't have to deal with collectors. If you have any questions or concerns, you can always call us no matter how often. This YouTube page that we have every day, Monday through Thursday, same time, is to also give information. Our second mission is to educate seniors how they can maintain their financial independence. So welcome. I welcome you to ask questions on the chat feature. Some of you have conversations amongst yourself, which is fine, and I try to pick out the questions and answer them. Bottom line is, we don't want, if you're a senior who's struggling with debt, we want you to understand you're going to be okay. You don't need to worry, and I explain why that is the case. So I'll start off by reading a note that someone contacted us. It says, I'm 68 years old. I'm single. I have a 13-year-old car that's paid for. I have 4 credit cards that total about $18,000. I live on Social Security of about $1,900 a month and a little bit of savings. And my credit card bills are way too big, they explain. I started with a debt consolidation company last fall, but they have yet to settle with any credit card, as promised. Well, they won't, but let's go on. About $1,800 is paid to them so far. Most of that money went to pay them. I can assure you that. After watching several of your videos, my question is, should I cancel this program and just let the credit card companies do what they do? Credit is already bad because of the non-payments for 6 months now. I have nothing they can take, and my Social Security and other little money is protected. I see no use to continue the debt consolidation if the outcome will be similar, except it's cost me a lot more money that I don't really have. Well, we'll start out by talking about debt management or debt consolidation. A lot of these companies advertise, and a lot of seniors get wrapped up with them. Okay? And they can be a trap for seniors. And why is that? Well, when people call these companies, with few exceptions, they don't give them the complete story. They're not going to tell a senior, by the way, your income is protected, your Social Security is protected, so is your pension. If you chose to not pay these bills, they couldn't collect anything from you. Even if they sued you, they can't touch your Social Security, they can't touch your pension. Instead, they tell seniors, to enroll with them, and the seniors make payments monthly and eventually realize that they're not really being helped. And eventually, if they find out about Helps and realize that their income is protected, they realize they didn't need to enroll with this company in the first place. So why do these companies not tell seniors the complete truth? If they told you the truth, that your income was protected and that you didn't have to pay this debt, then you wouldn't enroll with them and they wouldn't make money from you. And some of these companies have reason to believe that nearly a third of their clients are seniors. And so they would really cut back on their income. And some of these companies are for-profit. The debt settlement companies are the for-profit ones. The debt consolidation companies or debt management companies are normally non-profit, but they're all the same. The non-profit ones normally don't tell seniors about their protected income as well. And why is that? Well, because they're supported financially by the credit card companies. They get donations from the credit card companies to support them to try to help people pay their debt. Okay? And a lot of them have prearranged agreements with the credit card companies that if they collect some money and pay it to the credit card company, they get from a certain person, they get to keep a certain percentage of that money that person paid to pay that debt as a donation to them. So you can see they have a conflict of interest. if they were to tell you the complete truth that your income was protected, that you didn't need their help, you would enroll with them and they would make less money. And so even if they're nonprofit, they're in the business to make money. I guarantee it. The higher echelon people are getting paid a lot of money, and they don't want seniors. They don't want seniors to know the truth. That's essentially it. If the seniors knew the truth about their money being protected, they wouldn't enroll with them, and they would make less money. So kind of sad, but that's the way it is. I deal with it every day. I talk to too many seniors. Some of them put in utter poverty, making payments that they simply can't afford to pay. Okay. So this person wrote us this, can you advise me? Okay. And yeah, we tell them, first thing we tell them is, when they call, we go over their situation with them and we'd explain, well, your Social Security is protected. No one can touch it. You don't need to pay the credit card debt. You could stop paying the debt management company. You can call them on the phone right now and cancel and ask them to send any money back that they're still holding for you. If they're holding any, you can get it back. The other thing too about helps is, if you do have bad credit, you can rebuild your credit if that's what you're interested in. Most of our clients aren't, but if you are, we can help you with that. We have a program called 7 Steps to a 720 Credit Score. It's offered by 720 Credit Score, Phil Tyrone and his company. It's legitimate. Your credit is based on your recent credit history. So you can rebuild your credit within a year, year and a half, 2 years. And that program is free for clients of helps that have been part of helps for at least 90 days. Why 90 days? You have to be behind on your credit, your debt, before you can start to rebuild it. But you can rebuild it over time. A lot of our clients don't worry about that, but some who do, we have this program that's free to our clients. We pay this company some money every month, so they offer it free to our clients to help them rebuild their credit. So this person contacted us from Ohio, and they say, I received paperwork on a judgment against me from last November. And the company, I guess it's Unifund, has my banking information and is putting a freeze on my bank account. Well, I kind of doubt that, but let me read on. I received Social Security and a death benefit pension from my husband, which is in January, was converted into an annuity through Mutual of Omaha. The paperwork from them says it cannot be garnished, but does my bank know that? The same amount deposited every month, just showing Mutual of Omaha transfer, no longer listed as a death benefit. I have a mortgage to pay every month. My main bank is Citizens. Can they freeze my account? Please help. They say I have 5 days to respond. Okay. So we talk about this a lot, and so if you're a regular listener, you know what I'm going to say, but it's always nice to hear it again. If someone sues you and gets a judgment, okay, first off, they can't take your Social Security. It's protected under federal law. What about your pension? No, they can't take your pension. It's protected under a federal law called ERISA, Employment Retirement Income Security Act of 1974, ERISA. Or if it's not protected under ERISA, it'll be protected under a state law. Now, if you have a little annuity, that's going to be protected under a state law. It varies from state to state. But this is the important thing to remember, is that if your Social Security or another form of federal benefit is deposited into a bank account, a checking account, for example, that particular checking account is protected from garnishment by your bank automatically up to an amount equal to twice the amount of federal benefit you get each month. So if you got $1,500 in Social Security, and this person said they got, well, they didn't tell me, but let's say $1,500 in Social Security, that means $3,000 in your bank account is protected. That means money from a pension that wasn't a federal pension, or money from an annuity that deposited in that same account, as long as the balance in the account is less than twice the amount of your federal benefit, that money is also protected automatically. So in this case, 1,500 times 2, 3,000 is protected automatically. And what happens is, this rule went into the effect back in 2012 that instructed the banks how to protect this money. If they got rid of garnishment, they have to examine your bank account, and they can determine where money came. and there's a code where if it came from a federal source like Social Security or a VA benefit or federal retirement of some form, and then they take that amount of money that was from a federal source and they times that times 2, and then they automatically protect that. Now, under the rule, they have 48 hours to examine the account, 2 days, to determine if the account is protected. Now, they do that within just a few minutes, okay? So sometimes a person gets a writ of garnishment and they think, oh, I'm going to have to do something, when in fact they don't have to do anything because the bank's going to order that money be released. Now, if you had another bank account, like a savings account, that money wouldn't be automatically protected. But if the money in the savings account came from a protected source like your pension or your Social Security, definitely your Social Security, then it's going to be protected too, but not automatically. You'd have to file some paperwork to get it released, a claim of exemption or challenge to garnishment. So that's one reason we tell HELPS clients or people that are seniors that have been sued and in danger of garnishment just to have one bank account. That's the account to which your Social Security goes. As long as you keep the balance less than twice the amount of your federal benefit you get each month, your bank will protect that for you automatically. So we're going to tell this person in Ohio that they don't have anything to worry about. They're going to be fine. Okay? Okay, Kat asked, can you just call a credit card to close it or let it go by not paying it? Which is better? I am judgment-proof. Okay. Well, you can do it either way. If you don't pay it, they're just going to close it automatically for you. You know, if you call them on the phone, you might get some pushback or something like that. Normally our clients don't worry about calling them on the phone. Normally it's just already closed before they contact us. Okay. Okay. This person called us from New York. Hi, I would like to learn more about your company. Okay, HELPS is a national law firm that represents seniors who owe debt they can't afford to pay. That's what we are. And they go on to say, I'm 73, retired, living on Social Security. I have credit cards I am behind on and starting to get bothered monthly more and more. I want to contact you for more information. Thank you. I'm not a client yet. Okay, well, our phone number is 855-435-7787. 855-HELPS-US or helps us. You can call us anytime. We can go over your situation. We got a web page that's very good. You can spend hours on it. We also have scores of videos that you can look on that talk about HELPS. And as far as I know, we're the only law firm in the nation that does what we do, and that's specifically to represent seniors and disabled persons who owe debt to stop the collectors from harassing them. We don't file bankruptcy. Our clients don't need to file bankruptcy. In the rare occasion that they might need to file bankruptcy, I'm happy to refer people to file bankruptcy. I probably filed 30 or 40,000 bankruptcies before I started HELPS, so we know a little bit, more than a little bit, about seniors and their financial problems. And this person from New York, we're going to tell him that his Social Security is protected, that he's behind on these credit cards. He doesn't have to pay them. If he doesn't want to be harassed anymore, he can enroll in HELPS. He gives us the creditors he owes money to. We're going to send a cease and desist letter. And under federal law called the Fair Debt Collection Practices Act, they're not legally be able to call him or send him demand letters anymore. Tell him not to worry. This person contacted us. They're actually a member of HELPS, but it's a good question. I said, I am current member of HELPS. I have a couple questions relating to the letters that are going out. Which address would you prefer having? I see on some of them, they have like a corporate office, and then they have a mailing address that said payments. I have several letters to send, so I try to do a few each day. Thank you much for your help. Enjoy your day. Couple things to comment on. We normally send the cease and desist letter to the letter where the bill goes. Okay. We can send it to the corporate office, but I think when we send it to where the bill goes, it gets faster reaction. We tell people that enroll in helps to get us the creditors they owe money to. All we need is the name, address, and account number. We don't need the balance. And then our goal is within 24 to 48 hours to send in a cease and desist letter. And, it's got to get there. And then they've got to process it. And then, so it usually takes, 2 weeks, maybe up to 4 weeks for them to get it and stop the contact. In the meantime, if you're a member of HELPS, if they were to call you, you tell them that you're a member of HELPS law firm and that they're not to call you anymore. You give them our name and address, or give them our name and phone number, and you hang up the phone. Okay? But we don't want you to worry anymore. And they bring up another point. We don't need when you enroll in HELPS, we don't need everyone you owe money to all at once. You can dribble them in if you need to. And if you've been a member of HELPS for a while and you get a new debt collection notice from a new debt collector, as say one of your old collectors turned it over to a new debt collection agency, then you can get us that new address later on, okay, when you get that. And you don't need to talk to them. You definitely don't need to call them on the phone and tell them you're represented by HELPS. You don't need to put yourself through that. The person you talk to isn't going to know what to do. They need to get the notice from us in writing, okay? But we don't want you to worry. So Jeff's asking me, I have a riding lawnmower, a couple older ATVs, and an older utility trailer. I just got notification of a judgment. Are these items at risk? Highly unlikely. More than in 46 years of practice, I've never seen a debt collector ever go after an ATV, an older utility trailer, or a lawnmower, anything personal property like this. They simply don't do it. Why is that? Well, almost every state has what's called exemption laws that protect a certain amount of equity in certain property. Okay, and sometimes they have what's called a wild card exemption that covers an exemption in anything that's not specifically listed. But even if it's not part of the exemption for your state, it's just not the practice of judgment creditors to do it. Old ATVs are worthless. They're not worth very much. As is an old utility trailer and a lawnmower. No, they're not going to go after those. It'd be too complicated for them to do that. So, no, you don't need to worry about that, Jeff. Not at all. Question, can a bank debit MasterCard be connected with one MasterCard? It's one of those reloadable cards. No. If you've got a reloadable MasterCard, that's a different account, different bank. It's not tied in with a MasterCard that you owed money on that you weren't going to pay. Okay, so you don't need to worry about that that your reloadable MasterCard is at risk. Okay. Can a creditor still sell the debt to a collector if they sent me a 1099-C? Oh, absolutely. Usually a creditor is the one that sends a 1099-C, which is just a statement to the IRS saying that you didn't pay the debt, therefore this debt should be attributed as income to you, so you'd have to pay taxes. Now, creditors are technically required to send that in if the debt's over $600. So a lot of times they don't. But I talk a lot about 1099-Cs, and I'll talk about it again here real briefly. A 1099-C is a notice that a creditor sends to the IRS, and they send you a copy saying that you didn't pay the debt, and therefore this should be counted as income. Now, if you're required to file taxes, then you can file Form 982, and there's a box on there at the top that says if you're insolvent, which means if your debts exceed your assets, there's simply no tax, and you can file that. Now, if you're required to file the 1099-C and it does create a tax, most of our clients, if they owe the tax, can qualify to get on what's called currently not collectible status with the IRS. If you have income about $2,500 or less and a single person, or $3,500 or less, and a married couple, you can probably qualify for what's currently not collectible status with the IRS and not have to pay the tax. Now, if you're not required to file tax returns, if your only income is Social Security and you have just a small amount of other income, less than like $12,000 or $15,000, you're probably not required to file tax returns. And if you got a 1099-C, probably just forget it. I don't see the IRS following up on those. They can tell from your income that, even if you were required to file taxes, you wouldn't have to pay it, or that you could get on currently not collectible status. So if you're not required to file taxes and you get a 1099-C, normally you don't need to worry about it. And you could always deal with it later if it became a problem, but we just don't see it ever becoming a problem. Okay? So April asks, should we wait until the debt goes to a debt collector before becoming a client? No. If we have 5 clients that call us, April, maybe 1 is being sued, 3 or 4 out of 5 are being harassed by debt collectors. They're behind. But 1 out of 5 is completely current on everything. But they finally realize they can't pay the debt anymore. It doesn't matter where you are. You can enroll in helps at any point. Okay, so if you're current on everything, we're going to send a cease and desist letter out to the creditor to whom you owe money, the original creditor. Now, the Fair Debt Collection Practices Act, that law applies towards debt collectors, not original creditors. But there's about 7 or 8 states that take the Fair Debt Collection Practices Act. It's a federal law and applies it to states, and says that if you send a cease and desist letter out to an original creditor in our state, that means the original creditor can't bother you anymore. But it's our experience that when we send a cease and desist letter out, even to an original creditor, they're going to stop calling you. They may still send you a bill, but they're going to leave you alone. Okay? So no, it doesn't matter if you're behind or not. You don't have to wait till you're behind to enroll in helps. So the Fair Debt Collection Act, is that good for medical and dental bills, to tell them they have to leave you alone, and it's hospital, can they refuse to see you? Okay, 2 questions. So, the Fair Debt Collection Practices Act, which provides that, when we send a cease and desist letter out to a debt collector, they have to leave you alone. That includes, it's for a consumer debt, okay? And that includes a medical bill or a hospital bill for you, okay? They can't bother you. Are they going to refuse to see you? Well, if it's a public hospital, they can't. If it's your own doctor that you use regularly, sometimes we'll tell our clients, we'll just send them a little bit of money each month. They're getting paid primarily by Medicare, and they know that you don't have a lot of money, and you can send them a little bit of money each month, and that's probably going to keep them at bay. You may not want to rub salt in the wound to have us send them a cease and desist letter if you continue to see them. But if you pay them $10, $15, $20 a month, they're probably going to be happy paying towards the past debt. If you were added to your children's bank account over a decade ago, are those accounts included in monies they could garnish? Well, first off, they'd have to sue you and get a judgment. The rule is that twice the amount of federal benefits in a particular bank account that your name is on is automatically protected, regardless of what funds are in there or where they came from. So if you had a bank account and your Social Security went into it, and your daughter or son was also on that account to help you, as long as the balance is less than twice the amount, it's protected automatically. Now, if you had your name on their bank account to which their money goes, and there was more than twice the amount of federal benefits in the account, then there could be a problem. But that's probably not what you're talking about here. So in other words, if your kids are on the account with you, just keep the balance less than twice the amount of federal benefits, twice the amount of Social Security that goes in there each month. You don't even need to worry about that if you haven't been sued, okay? And if you're sued, then you have time to change or adjust the bank account. Got it? So Brent asks, in addition to my Social Security, I occasionally do freelance jobs. The gross revenue are deposited by ACH into my business bank account. Can that be garnished? It depends on the type of bank account you have for your business. If it's a corporation account, like a LLC, limited liability corporation, or subchapter S corporation, then that's technically a separate legal entity and in the bank account. And no, it can't be garnished. They'd have to have a judgment against the corporation, which they don't. They'd have to, but But if it's an assumed business name and the bank account is in your name only, then yeah, that money could be at risk. So in that case, if you did a couple freelance jobs and a little bit of money, you probably don't need that extra bank account. You just run those funds through your own bank account into which your Social Security goes. As long as you keep the balance in there less than twice the amount of Social Security each month, then if a creditor were to sue you, get a judgment, and happen to garnish your bank account, it's going to be protected. Okay? But remember, none of this is going to happen unless you're sued first. Now, what about your income? Is that at risk? No, not really. You're working freelance. You're working for different people. If a creditor would garnish you or get a judgment against you, they wouldn't know about this extra income, so that's really not going to be an issue. Brian asks, my wife and I have our own bank accounts at different banks. Is that okay? She has no debt in her name. Yeah, there's no problem. If the debt is in your name, then if you got sued, it'd be just you being sued. Therefore, twice the amount of your federal benefit in your bank account is in your name is protected automatically. Okay? How do you know if your bank will protect you? Who do you call at the bank and will they tell you? That's a good question. I've asked that before. I don't mean to laugh, but I laugh because it was a problem. This rule that protects your money in your bank account that Social Security came into effect in 2012, I'm kind of surprised it didn't come in sooner. That was the year helps got started. And what was happening is seniors were getting garnished. And a lot of them didn't realize that their bank account, the money in their bank account was protected, and they didn't file paperwork with the court to get the Social Security release, and so they were losing their Social Security, weren't able to pay their rent, and they probably started complaining to their congressman, and so finally the federal government put a rule into place that instructed banks that they're to automatically protect twice the monthly amount of federal benefits like Social Security deposited into a bank account from garnishment without the senior or disabled person, the person getting the protected income, having to do anything at all. That was a smart rule. Probably saved a lot of complaints to congressmen and a lot of heartache to seniors that were being garnished and losing the money and didn't realize they could get it back or prevent the garnishment from happening. So that's been in effect since 2012. Do you need to let the bank know? Well, I'll tell you this. I've yet to meet a bank manager that understands the rule. And I've said before, and I'll stand by it, that I would bet that 999 out of 1,000 attorneys don't know that rule, even though it's been in effect in 2012. But I can assure you there's a department in your bank that deals with garnishments that understands the rule. Okay? Now, at the beginning, we did have a few problems over the years, and we'd have to contact banks. We'd have to, we've got a huge email that goes into great detail that quotes the law that we've had to send in the past to banks. We did have a problem for quite a while with credit unions not getting the word right. They march to their own tune, and sometimes they would garnish, and we'd have to educate the credit union on this fact. But now we don't have that problem anymore that I can recall. I mean, I used to say we used to get complaints once a year. I can't remember the last time we heard about a credit union making the mistake, but no, you don't need to worry. You don't. And if you were to contact someone at the bank, the teller or your bank manager, they're either going to give you the wrong information or they're going to say they don't know. Okay. Okay. So this person contacted us from Illinois. Hello, I am disabled, a single mother who just went through a divorce. After my spouse left, I could no longer afford to continue payments on the many credit cards I had. Now I'm being sued by one of them. My only income is Social Security disability, child support, and spousal support as well. And she gets other benefits. And I was awarded the family home in the divorce, that I'm paying a mortgage on. The court date is set for March 14th. I'm not sure what I can do. Probably don't need to do anything, and I'll explain why. So this person, their only income is Social Security disability. That's going to be protected. And it sounds like they've been sued. They have a court date. If you owe the money, you don't necessarily need to go to court. If you go to court, you're probably going to lose because you owe the money. Okay? If you want to try to fight it, you can, but you don't need to. If they get a judgment, twice the amount of your Social Security deposit in your bank account is protected automatically from garnishment. What about child support you're getting and spouse support? Well, that's protected too. No one can garnish your child support. No one can garnish your spousal support. Only problem is it may not be protected automatically into the bank account to which it's deposited. So if you get a paper check and you deposit in your bank account and it brings the balance over twice the amount of your Social Security getting each month, then if the creditor had a judgment and they would garnish your bank account at the exact right time, they could maybe hold up some of that money and you have to file some paperwork to get the excess released. But if you can adjust your account so you never have more than twice the amount of federal benefit in your bank account at any one time, then if they were to garnish the bank account, they wouldn't get anything. Normally, in most states, a garnishment on a bank account is a snapshot in time, which means if they get rid of garnishment, they look at your bank account let's say at 10 o'clock in the morning when they open up the mail and look at the garnishment. And they look at your account, and if you got $1,500 in Social Security, let's say you had $2,900 in your bank account, and they'll say, oh, there's less than twice the amount, $3,000 in there. They rip up the garnishment, throw it away. Now let's say 1 o'clock in the afternoon, spousal support and alimony went in there, and it doubled the amount you had in your account. Well, the garnishment's already taken place. They've already answered it, so no, it won't be a factor. Okay. And if there's ever a problem like this, you'd call us. We go over it with you. But normally there never is, very rarely. And if there is, it can be resolved because your Social Security is protected, so is your child support, and so is your alimony. No one's going to be able to garnish that. So this person contacts us from Mississippi. My spouse and I are in over our heads in credit card debt due to the high cost of food, gas, and medicine, and day-to-day monthly bills, and a mortgage. They have a first and second. I am soon to be 73 and my spouse is 71. We both live on Social Security, and my spouse has a pension. So what are we going to tell them? Their Social Security and their pension is protected. They don't need to pay the credit card debt. Now, we're going to talk to them about their home. Almost every state has what's called a homestead exemption, which is an amount of equity that you can have in a home that's protected from debt collectors trying to take your home. But even if you have equity in a home over and above the homestead exemption in your state, it's not the practice of consumer judgment creditors to go after your home. They don't do it for a lot of reasons. Some states protect the entire amount of equity you have in your home. Examples are like Texas and Florida. And there's several other states that do that as well. And a lot of states have, large exemptions. California, it's at least $600,000. Nevada, I think it's $400,000 or something like that. And Arizona, it's $400,000. It depends on your state. Then some states had really small exemptions. Some states, I think like Virginia, only has $5,000 homestead exemption. Well, let's say you have a home in Virginia and you've got a $50,000 equity in your home over and above what you owe, and a creditor were to sue you, are they going to try to take your home? No, they don't. It's not the practice of consumer judgment creditors to go after your home for a lot of different reasons. Maybe you own the home with your spouse and the debt is just in your name, okay? Then someone else has an interest on the home. It's virtually impossible for a debt collector to unwind that and try to get that property. And if they were ever to do that, there are ways to stop it or prevent it. But there's just not an issue of them trying to take your home. So that's not going to happen for this person. So we're going to tell them, if they want, they can enroll in helps. Now, if they went to a bankruptcy attorney, they could have a problem because the bankruptcy attorney might say, well, you live in Mississippi. And I'm trying to think, but I think the exemption in Mississippi is like $15,000. It could be double that for a couple, but let's say they had exemption over and above that. And if you went to a bankruptcy attorney, they'd say, well, you can't file regular bankruptcy. The only thing you can do is file a Chapter 13, and then under a Chapter 13, you'd have to pay your creditors back over 3 to 5 years. Well, that might be kind of difficult. If your income is lower, you don't need to be in a Chapter 13 because, like I said, a creditor isn't going to try to take your home. So you don't need to try to pay the creditors back. So if you have any of these questions, detailed stuff, you give us a call. We'll go over your situation. Helps. We don't give legal advice. We give legal information. And that's what I'm telling you is what the law is, what happens. Okay? So this person contacts us from California. I'm thinking about doing a surrender of our travel trailer. We talk about that a lot. First time today. We're over 20,000 upside down, and we've been paying out for 3 years. A lot of people have a RV that they find they can't afford. Maybe one of the spouses got sick, and they just can't drive it. They don't use it. Maybe they've had mechanical problems, and for different reasons they just can't afford it anymore. Okay, we have tried to sell it. They say we've asked them to modify the interest rate, and they won't do that. See, if they started modifying the interest rate on these loans, these lenders would, they'd have everyone on earth calling them to do that, and so they just have flat rules that they don't do it. Okay. We paid $50,000 and put $10,000 down, and the balance is still $38,000. Can you help us with this? Sure. What we're going to tell you is that if you can't afford the RV, you can stop making the payment and let it go back. Don't call them and tell them that you can't afford it anymore. You wait till they call you when you're behind on the payment. If you call them when you're current, you'll never get through to the right person. You got to be behind, and eventually they're going to pick it up, and they're going to sell it. If you want them to pick it up faster and you don't drive it, you could leave it parked and take the insurance off it. They might pick it up faster. If you have it parked at a place where you have to pay a monthly fee and you can't afford it, you could stop paying that monthly fee, and the lender's going to have to pay that when they pick it up. So anyway, they're going to pick it up, and then they're going to sell it. And then when they sell it, they're going to likely sell it for less than what you owe. The difference is called a deficiency. The amount that you're deficient between what the loan balance you owe is and what they get for the RV. And they're going to send you a letter saying you need to pay this to us. And then at that point, if you're enrolled, it helps. You get us that letter. We're going to send a cease and desist letter out to the lender, let him know that you can't afford to pay it and you're not going to pay it. Now, meanwhile, if you had other debt as well, you wouldn't have to pay that either. Social Security, credit cards or medical bills or other stuff as well. But no, this person, you're not going to have to worry about the RV. Pretty common. Okay. This person contacts us from Kansas. I'm 80 years old, and my only source of income is Social Security and a small pension. I'm getting calls about some kind of debt that I owe, but they don't say who or what it's in reference to. Well, if those kind of calls could be a scam call, but I'll go on. They gave no name and no number to call back. This is probably in reference to a credit card debt I owe to Capital One, but I'm not sure. The number that comes up shows to be from Pakistan. Okay. It's probably a scam call. I rent and have no stocks or bonds or any real assets. I heard about you online. Anything you can do will be appreciated. Thank you. Well, I'd say this to anyone that's listening to me, whether you're a member of Helps or not, and you think that you may be scammed and being taken advantage of, you can always call us and we'll be happy to answer that question or go over that with you. We probably talk to more seniors than anyone in the country, I'm sure of that have been subject to scams. We don't want anyone to be subject to a scam. So, you know, you can actually get on the internet and you can find call banks in certain foreign countries where there'll be little cubicles and these foreigners are calling all day long trying to take advantage or scam people. And this call you're getting from overseas could be based on an old debt. It could be on that debt or some other debt, or they just got your name from some number list somehow. I tell seniors that have been scammed, if you've been scammed once, you're going to get on a list and they're going to try to do it again. Okay? We got videos that talk about various forms of scams, but if you got a question, we want you to call us. I don't want you to be scammed. And they're scam debt collectors. They find out about an old debt and they'll call you, try to collect on it, even though they have no authority to collect on it. Okay? My brother is disabled. Can he stop a child support deduction? Probably not. If he gets Social Security can garnish child support can garnish Social Security up to a maximum of 60%. Probably less than that, but if you're on SSI and you're under a certain amount of Social Security, that even can't be touched. Okay. Okay. This person contacts us from Kansas. I'm 80 years old and my only source of income is Social Security and a small pension. I'm getting calls about some kind of debt I owe. Oh, that was the one I just read. I'm sorry. This person contacts us from Texas then. I've been sued in small claims court in the amount of $1,600 and have need of an attorney. My hearing is set for Monday, February 17th. Today. Thank you. Well, I'm sure we've already contacted this person. And we probably told them, I said, well, if you're on Social Security or a pension and retirement income and you owe this debt, you don't have to go to the small claims court. I mean, if you want to contest it and you don't owe it, certainly go and contest it. Small claims is designed for persons that aren't attorneys to go to court. But part of the problem with small claims on debt collection is that if a debt collector is a corporation, then an attorney can represent the corporation, can represent them in small claims court. So we'd be telling this person, you don't need to go to court if you don't want to. They live in Texas. If they get a judgment, your Social Security is going to be protected, so is your pension. In Texas, they can't garnish wages. They're going to be perfectly okay. So this person contacted us from Ohio, and they say, I just saw you on YouTube and need help after losing my husband in December with his remaining bills. So what do we tell this person is if the debts were in the husband's name and not your name, and you're getting debt collection notices for the husband and he passed away, and he didn't have an estate, which likely he didn't. When he passed away, any assets he have just went automatically to you as a spouse. But what you can do is just take a copy of the death certificate, staple it to the bill, and then write on the bill, no probate, no assets, no probate, and send it back. And they're going to leave you alone. They're going to stop bothering you. Okay? So Lavender asks, I have two leased cars and need to let one go back. I can't afford it anymore. If I keep making payments on the second one, will they repossess that one too? Please let me know. Well, I'm kind of assuming that these are the same lender. If that's the case, uh, normally no, they wouldn't. If you're defaulted on one and you're not defaulted on the other, they're not going to take the other one. They only can take the one. The two loans normally aren't tied together. Okay. It could be an exception if you lease the car through a credit union loan, but I doubt a credit union engages in car leases. So I don't see you having a problem if you let the one go back and keep making the payment on the other one. Okay? So this person contacts us from California. My question is about gambling and credit card debt. I'm $90,000 in credit card debt. Should I declare bankruptcy? I have a reverse loan on my home. I cannot refinance until the value goes up $100,000. Well, I can tell you, no, it doesn't matter how the debt was incurred. Yeah, if you're on a reverse mortgage, you're at least over 62. You're getting Social Security and a pension. It's protected. No one can take it. If you live in California, you have a homestead exemption of $600,000 at least, depending on the county where you live. Probably, definitely more than that. So, no, your home can't be taken. And if you've homesteaded the property in California, you could still sell the home and get all the money out of it. So you don't really need to file bankruptcy. Okay? And if you owe the credit card debt because of gambling, doesn't mean that that it's any different type of debt. No, that's not the case. Don't need to worry. Okay, yeah, it's the same company. Yeah, if the two loans were taken at two different times. So this person contacts us from Washington and they say, I'm a senior citizen receiving Social Security, but I'm not disabled. I have a loan with my bank and a credit card. The loan is unsecured and says, and I consolidated my debt in 2023. Rather than paying several companies, the bank paid them and set up a loan that had monthly payments of the same amount per month. So it sounds like this person had different debt and they went to their bank and the bank took all their debt, paid it off, and now they have one loan to the bank where they do their banking. The biggest problem is the credit card with the same bank. Not only is the minimum payment large on the fairly small credit card balance, but the interest rate is horrible. I can't afford and have been taking money from savings to pay medical, dental, and other bills to keep up. I am so scared to lose all my savings. I just recently did a video with Senior Living and we talked about, financial mistakes seniors can make. And one of them is to use your retirement funds like an IRA or 401k where there's a limited amount of money to use that money to pay your debt because once that money's gone, you can't repossess it. And the money in your 401k and your IRA, that savings money that you have, is protected and can't be taken. So using it to pay debt, and when you find out it's gone and you still owe the debt, then that your nest egg, that 401k or that IRA is gone. It's not there. So they go on to say, I made the mistake of signing up with a credit consolidation company, but they said it could take up to 120 days to settle, and that means my debt will go way above the $25,000 currently because of the interest and probably penalty fees. What I will have to pay them monthly will probably be higher. Even worse, my bank wrote that they will not negotiate the loan for a lower monthly payment. Please help me. Well, this is going to be pretty easy. Okay, the person's a senior citizen that gets Social Security. And it sounds like that's the only income they're getting. They could stop paying their bank, and they could stop the bank loan, and they could stop paying the credit card debt, and any other credit card debt they have. And they could, when they signed up with this debt consolidation company, one thing I'd ask them is, when you signed up with them, did they tell you when you enrolled with them that your income was protected, that you didn't need to pay the debt? And I can guarantee the answer was no. They didn't tell them that. I've explained earlier, like today, why they don't do that. If they did that, then the person would realize they don't need to pay the debt, and they wouldn't enroll with them, and this company wouldn't get paid. I'm talking about the debt consolidation company. That's how they make their money, by signing up people for debt consolidation. And if the person realized they didn't need debt consolidation, they wouldn't enroll with them, and they would get fewer clients and make less money. So this person doesn't need to worry. Okay, they could stop. Now, are they going to need to change their bank accounts? Maybe. It might not be a bad idea, because usually, if you're not going to pay the credit card debt, why would you pay the other loan you have with the same bank? You might as well just, stop paying them. If it's an automatic payment, you could call the bank and tell them you want to make it yourself, and then contact Social Security, open up a different bank account somewhere else. And if you let Social Security know that you've got a new bank account, and give them the routing number for the new bank, if you do it by the 10th of the month, normally by the next month your Social Security will go into that different bank. But if you miss a payment to your bank that takes money out automatically because you stopped paying them, or you stopped the automatic payment with them, they're not going to take money out of your account or do anything unless you're a couple months behind. And if your only money that's Social Security that's going into that account, technically they can't even take money out of your account to offset for a loan that you owe them. So we'll explain to this person from Washington what they can do, and how they're going to be okay, and they have nothing to worry about. So, if you're new to this channel and you're just listening to this first time, we've got lots of videos and lots of information on our website that talk about helps in what we do. We represent seniors and disabled persons who owe debt to stop collectors from harassing them. We inform them how their income is protected, how they can stop paying their debt, and how we can stop creditors from calling them, sending them demand letters. And they can always call helps with their questions, no matter how often. We don't want you to worry. So this person from Texas contacted us. Hello, I have 5 installment loans that I can't keep making payments on. I receive Social Security disability once a month. The total amount owed for all the loans is, it looks like $2,500. That's what they pay each month. If you can help me, please give me a call. And they gave us the number. Yeah, we're going to call them. We can tell them, yeah, we can help you. You get Social Security disability. It's protected. It can't be taken from you. You can stop paying all these debts and use that money for your food and your medicine and your needs. Okay? Lawmakers protected your Social Security and your pension, your disability, and these other forms of income, of retirement, so you'd have enough money to live and you wouldn't have to go without heat or medicine or food. Now, I realize that sometimes, when we pay rent and other basics, there still may not be enough money to pay for rent or for utilities. I understand that, and I wish I could solve that problem. But I tell people this, that are struggling with the basics. If they realize they don't have to pay their credit card debt and these other loans that they have out there, then maybe they're going to have more money available for their needs. Okay? So, I'll finish up with this one. It says, my mom will be turned 90 in November of this year. She lives with my sister and me, and she's ready to start looking into assisted living, but is panicked about a Discover bill for $17,000. High interest rate. She's always paid her bills and always had good credit. She's convinced she will not be accepted into assisted living. Excuse me. I've explained to her many times that she's judgment proof and just stop paying it. And I've also explained she doesn't need to file bankruptcy. Heaven forbid if an attorney ever filed a bankruptcy for a 90-year-old person, a widow. Oh my. And she says, Mom doesn't believe me. And she cries and says they'll come get her. I could not believe my luck when I found a video of you and your website. I had no idea services such as yours existed. Yeah, we do exist. We live in Colorado. Yeah, so what we'll do, we'll call this person back and we'll talk to the daughter and the mom together. Now, the mom may not trust the daughter, but I guarantee the mom will trust me. Pretty sure she will. Or one of our other attorneys or paralegals that helps. We're always thrilled to talk with a senior and one of the kids when that's necessary. Not always necessary, of course, but sometimes it just helps. So if you're calling about a parent, yeah, we're happy to talk to you about your parent, and we're also happy to talk about you and your parent together. Okay? That's what helps us here for. And so it's been an hour. It's Monday, and we've got the rest of the week. I'll be here tomorrow at the same time. I want to thank you for your questions. If you have any more questions, or if this is like something in your mind that you need to ask, be sure and call us. Toll free 855 helps US or helps us 855-435-7787. And everyone have a great day, and I'll talk to you tomorrow. Same time. God bless.